Hey everybody. Time for us to dig into the third and final branch of government. We've talked about Article 1 in the Constitution in the legislative branch, Chapter 9. We've talked about Article 2, the executive branch, including the president and the bureaucracy, in Chapter 10 and Chapter 11. And now we're talking about the third branch of government, the judiciary. Okay? Now the judiciary is the third branch of government discussed in Article 3. Definitely make sure you know that. And generally speaking, what does the judicial branch do? What is the job of the court system, folks? Now, we've talked about the legislative branch, which is Congress. Their job is to make the laws. Chapter 10 on the president and the executive branch. The executive branch's job is to enforce the laws. And the third branch of government, the federal court system, the judicial branch, its job is to interpret the law. Interpret the law. Now, the most important part of interpreting the law is judicial review. Absolutely. Make sure you know judicial review for the exam. Judicial review is something you absolutely must know for the exam. It is the ability of the courts to strike down anything that violates the Constitution. Okay, they can strike down anything that violates the Constitution. Actions by the president. Laws, executive orders, regulations, actions by local governments. They can strike down anything that violates the Constitution. Now, like I said, the court system is explained in Article 3, starting with its qualifications. What does it take to be a judge, a federal judge? Trick question. There are no qualifications. There are no qualifications because the Constitution has not set any qualifications. Judges are simply selected. They're simply selected and then voted on, and we'll talk about that here in just a few. Now, when you become a judge, you actually serve a life term, also known as good behavior. Basically means as long as you're not violating the law, you're living within the law, your term is never over. You get to serve as long as you want to until you retire, or in the case of some judges, until you die. We actually had a judge die back in 2016 and replaced them early this year in 2017. Now, to get your case heard, there's a very, sequenced chain of events that have to occur. First of all, you need to have jurisdiction, which means you need to be in the right district. Certain courts cover certain areas of the country. You got to be in the right district to get your case heard by a particular court. You also, for federal courts, need to have a federal question, which is a problem, a controversy, a question that a federal judge would be needed for rather than a parking ticket. Parking tickets and speeding tickets, those are taken up with municipal courts, local courts. If you want to talk to a federal court, you got to have a federal issue. Frequently, a federal issue involves diversity of citizenship, meaning the two parties that are arguing with each other are from two different districts. If they're from two different districts, then a federal court will oftentimes take them up. If you live in South Carolina and I live in Georgia, these are two different states. Therefore, a South Carolina court or a Georgia court might be unfair for both of us or for either of us. So as a result, got to have diversity of citizenship usually to get your case heard on a federal court level. You also need, I always struggle with this word, justiciable controversy. You need a justiciable controversy, which means it can't be a theoretical conflict. It has to be a real conflict. To get your case heard, something really needs to be happening between you and the other party. Now, most cases involve two parties that are in conflict with each other, but that's not always the case. Sometimes it's one party versus a whole group of other people. We call that a class action lawsuit, or a whole bunch of people are involved as one of the two parties in the suit. Other times, there are third parties that are not involved in the conflict but still want to contribute to the arguments being made, maybe because they have something writing on how the court decides, right? So we call these amicus curiae briefs. Amicus curiae briefs are, again, put in by third parties that are not involved in the conflict, but they, want to file some arguments on behalf of somebody who is. So the federal court system is three-tiered. The first tier is what we call district courts. Now, this When you watch courts on TV, this is almost always what you're watching. This is where you're going to have a jury and evidence being presented and cross-examinations and I object and all those classic things that you're used to seeing on court, on fictional courts in movies and TV. You're usually watching something akin to a district court, right? And then the district court will say somebody wins and somebody loses. So what does the losing side do? Almost every time, they will appeal. Now, after the district courts, there's about 90 some of these throughout the country, there are 13 courts of appeals, also known as appellate courts, that are spread throughout the land. Now, these appellate courts do not have all the super dramatic stuff like a jury and evidence. Instead, they just decide whether the previous court, the district court below them, decided the case correctly. This will really just involve a panel of judges and then a lawyer for me and a lawyer for you. Both sides will put in their arguments, and then the Court of Appeals will say, oh, the district court beneath us got it right, or the district court beneath us got it wrong. Then, after you have a winner and loser at that point, the loser will almost always appeal to the Supreme Court. The Supreme Court's just one court in the entire country. And since there are thousands and thousands and thousands of court cases, they only hear about 70 a year. So of the 9 judges that sit on the Supreme Court, you actually need 4 of them to even agree to hear your case before you get a chance to present before the Supreme Court. Supreme Court only does that with about, like I said, 70 cases a year. So that means your chances of being heard by the Supreme Court are very, very low. How Supreme Court cases work, typically, 2 involved parties take a dispute to the court, let's say Mr. A or Mrs. A versus Mr. B. Then both of the parties file briefs with the court. Now, these are written documents just explaining their point of view in a couple pages. They're brief. That's why they're called briefs. Then there's an oral argument. Mrs. A's side and Mr. B's side will both get, a half hour each to argue in front of the Supreme Court. After that, the judges will excuse themselves and confer and then issue their ruling, what we call an opinion. Now, there are many different parts to an opinion. There's a majority opinion every single time, meaning this is what the majority of the court has concluded. They have concluded, in this hypothetical anyways, that A wins and B loses for the following reasons. Reasons 1, 2, and 3. And the majority opinion always issues their reasons because they want to guide future cases that might be on a similar issue, right? In addition to that, if there is within that majority of judges, if there's a couple judges that disagree on the reasoning, they will get an opportunity to put in a concurring opinion. Now, a concurring opinion is for judges who agree with the conclusion, but they disagree with the majority's reasoning. So they say, well, yeah, A should have won, but it should have been for reasons 4, 5, and 6, not for reasons 1, 2, and 3. Okay? Now, the concurring opinion has no legal authority. The only thing that matters for this court is the majority opinion. But nonetheless, judges are divas, and so we give them the ability to complain that the court should have decided the case, in this case, slightly differently. A still should have won, according to the concurring judges, but it should have been for a different set of reasons. The dissent also has no legal authority, and this is for the judges that are in the minority. This is the dissenting opinion. They say B should have won. Obviously, this has no legal authority. It's just a platform for them to complain. So when judges are issuing their opinion on the Supreme Court, they're always weighing on what the lower courts have concluded. They will affirm sometimes, saying the lower court got it right. They will reverse what the lower court did sometimes, saying the lower court got it wrong. Other times, they won't rule that the lower court got it right or wrong, just that they made a mistake and that the case needs to be sent back to the lower court. That's what we call remanding. Make sure you know all 3 of these. You'll be seeing this on the exam for sure. And then, of course, whoever's on the losing side of this opinion could appeal for any other court case. Typically, obviously, you can't appeal a Supreme Court decision. There's no court above the Supreme Court to appeal to. Now, typically, we talk about a judge's rulings. Okay, what guides a judge's rulings? Judges can't simply rule whatever they want whenever they want. So instead, courts have to follow major guidelines. One of these is called precedent, meaning they got to follow whatever that court has previously ruled. So if you are a, we'll say, district court, and you've ruled that the right to, that flag burning is perfectly constitutional as free speech. If you rule that, then that's your court's point of view forever. Okay? If you stay on that district court and 10 years later you change your mind, too bad. Okay? You can't change your mind as a court. A higher court can overrule you, but you cannot overrule your own previous rulings. That's what we call precedent. There's also stare decisis, which says, as you probably already know, courts have to follow whatever the courts directly above them have ruled. So, certain district courts belong to the district of an appellate court, and and they have to follow what the appellate court rules, and all courts have to follow what the Supreme Court rules. You have to follow what the courts directly above you have ruled. Does the Supreme Court have the power to overrule its past decisions? Really just depends who you ask. That's a big controversy, and that hasn't been settled in any significant way. So how do you exactly become a judge? Well, there's a two-step process. The first step is nomination. You must be appointed by the president. Okay, so the president will nominate you for to be a judge, a federal judge, for any number of reasons. Really, he can name you for any reason he wants or she wants, if we have a female president. The president can name you for any reason. He just likes how your hair looks. Okay? The president really can name people for any reason. But there are major factors that the president uses. For instance, he wants to name somebody who's qualified. We want to make sure our judges are qualified. And in addition to that, the president also wants the judge to agree with him on ideology. For instance, you'll notice that conservative presidents normally name conservative judges. Liberal presidents normally name liberal judges. So obviously, not only do our presidents want judges to be qualified, they also want them to agree with their politics. Now, the president doesn't get to appoint just anybody he wants. I mean, he totally can, but that person that he nominates must be confirmed by the Senate. Got to be confirmed by the Senate. So, if the president names, Mr. Crocker to be his new Supreme Court judge, I'm probably not going to be confirmed by the Senate. So the president can't just pick me. He can pick me as for his nomination, but he's going to lose. I'm not going to get confirmed by the Senate. So he wants to pick somebody really, really qualified who agrees with him politically. And that's a short lecture, but that's what we have on the court system. Make sure you understand the court system and Chapter 12. A lot of people tend to sleep a bit on this chapter, so please understand it before you take your exam. Good luck.